Second Amendment rights are being infringed upon.
Justice's decision could impact concealed carry laws.
I was truly alarmed by the decision. In other countries, when they have mass shootings, they tighten down their gun law.
Criminals just go get a gun. They don't care.
You're not going to solve any sort of gun violence in the city.
A federal circuit court just issued an emergency ruling striking down the core of the concealed carry permit system, and every single judge on the panel agreed. Not one dissent. The ruling found that requiring citizens to obtain government permission before carrying a firearm in public violates the Second Amendment. This applies right now to every state under that circuit's jurisdiction, potentially affecting tens of millions of permit holders and applicants. I'm going to break down exactly what this means for you, what it does not mean, and what you need to do about it starting today. If you carry a firearm for self-defense, if you have ever applied for a concealed carry permit, if you have ever paid fees, waited months, submitted fingerprints, or sat through interviews just to exercise a right that is already yours under the Constitution, this ruling directly touches your life, and here is what should bother you. This barely made the news. The mainstream outlets either buried it or ignored it entirely. The people who should be telling you about this stayed quiet. That is exactly why we are here right now. Your ability to legally carry in public just changed, and the clock is already ticking on how states are going to respond.
U.S. Supreme Court today hearing arguments on Hawaii's strict gun law. The justice's decision could impact concealed carry laws.
Mass shootings, they tighten down their gun law.
All right, so let me walk you through what actually happened and why this is as significant as it sounds. A coalition of gun rights organizations brought a federal challenge against the entire permitting framework. They argued that the system itself is unconstitutional under the Second Amendment. The case moved fast because the core argument was straightforward. The government should not have the power to make you ask permission before you exercise a fundamental constitutional right. The plaintiffs leaned heavily on New York State Rifle and Pistol Association v. Bruin. That is the landmark 2022 Supreme Court case, where the court ruled 6-3 that the Second Amendment protects an individual's right to carry a handgun in public for self-defense. Bruin established the historical text and tradition test. That means any modern gun regulation has to be consistent with the historical tradition of firearm regulation at the time the Second Amendment was ratified. That is the legal standard now, and it is exactly the standard this panel applied. The court examined the history of permitting systems in this country and compared them against what the founders intended. The majority opinion found that the current permit regime exceeded what the historical record could justify. In plain language, the court said the system went too far and they shut it down. Every judge on the panel agreed on the core holding. A unanimous decision on a Second Amendment case at the federal circuit level is extremely rare. It tells you how clearly one-sided the legal argument was.
There's big news coming from the Supreme Court today, announcing this morning it will take up a major Second Amendment case.
They didn't sign up for this, so they don't want this, right? They don't want to be subjected to more gun violence than they already are right now.
Now here's where I need you to pay close attention, because this is the part that actually changes your daily life. Before this ruling, if you wanted to carry concealed in public, you had to go through your state. You filled out forms, submitted to background checks, paid fees, and in some states you waited months. Some states operated under what is called a may-issue system. That meant local officials like your county sheriff had broad discretion to deny your application for essentially any reason. They could look at your background, your stated reason for wanting to carry, and simply decide you did not demonstrate enough need. That is the same framework the Supreme Court struck down in Bruin, and this ruling drives that nail even deeper. What this court said is that the government cannot condition the exercise of a constitutional right on a bureaucratic approval process. The burden has flipped. Before, you had to prove to the government that you deserve to carry. Now the government has to prove there is a specific legal reason you should not be allowed to. That is a fundamental shift in how your rights work in practice.
In order to get a permit to carry a gun, you had to give them a reason why you needed it.
But let me be straight with you about what this ruling does not do, because there is a lot of bad information circulating online right now. This ruling does not mean you can carry a firearm anywhere without any restrictions. Federal law under 18 U.S.C. section 922 Gs, that is the federal prohibited person statute, still applies. If you are a convicted felon, if you have been adjudicated mentally defective, if you fall into any of the prohibited categories, this ruling does not change your status. You are still prohibited. Additionally, laws governing where you can carry still stand. Federal buildings, schools under the Gun-Free School Zones Act, that is 18 U.S.C. section 922Q, airports, courthouses, those restrictions remain in effect. This ruling addresses who gets to carry. It does not rewrite where carrying is permitted. Those are two completely different legal questions. Here's the other thing you need to understand. This ruling applies directly to states within the issuing circuit's jurisdiction. It does not automatically apply to all 50 states. However, and this is critical, other federal circuits are watching. There are cases stacked up across the country that have been waiting for exactly this kind of precedent. Cases like Bianchi v. Brown in the Fourth Circuit challenging Maryland's assault weapons ban, cases working through the Ninth Circuit post-Bruin, challenges to Illinois' Protect Illinois Communities Act. That is SB 22226, the state's assault weapons and magazine ban. When a ruling this strong comes down with 0 dissents, it sends a signal to every other federal court considering similar challenges. The momentum here is building in one direction.
Nation's highest court has ruled that Americans have a right to carry firearms in public for self-defense.
Having the ruling that the Supreme Court had today, being able to defend yourself, defend your family, does not stop at your front door.
Now let me talk about the ripple effects that are going to play out over the coming months. First, states that fall under this ruling are going to scramble. Some will comply and begin dismantling their permitting systems. Others, and you know which ones I'm talking about, will try to pass emergency legislation designed to achieve the same result through different legal language. They will rename the permit, restructure the fees, call it a safety certification instead of a carry license, and hope the courts do not notice. Courts will notice, and those new laws will face immediate legal challenges citing this exact ruling. Second, federal agencies are going to have to adapt, the ATF, the FBI, and agencies that rely on state permit data for background tracking and enforcement built their systems around a framework that just got destabilized. When states stop issuing permits, those agencies lose a data pipeline they have depended on for decades.
Right now, Michiganders must obtain a permit to carry a concealed gun with a base fee of $100.
Empire State they sought to prohibit people from carrying weapons in public.
State law restricts open carry permits to only counties with populations less than 200,000 people.
Making the concealed carry permitting process more lax, you're not going to solve any sort of gun violence in the city.
Third, if you travel between states with your firearm, your situation just got significantly more complicated in the short term. Not every state is covered by this ruling yet. State constitutional provisions operate independently. You need to know the specific laws in every state you pass through, not just your home state. The legal map of where you can carry is going to look very different in 6 months. Your current knowledge may already be outdated. So is this a total win? No. Let me be honest with you. The ruling is strong. It is unanimous and it is grounded firmly in Bruin. But the legal process is far from over. There will be appeals. The losing side will petition for an en banc rehearing. That means asking the full circuit court, not just the panel, to reconsider. If that fails, they will petition the Supreme Court for certiorari. That is asking the court to take the case. Given that Bruin already established the framework this ruling relies on, I would put the chances of a successful reversal at maybe 15 to 20%. But 15 to 20% is not zero. In the meantime, states are going to throw everything they have at preserving their control over who gets to carry.
Court is expected to rule on a new law banning high-capacity magazines.
Justice Clarence Thomas recently, who said that he believed the court now considered the Second Amendment, Kate, a disfavored right.
When we exercise our right to worship, we do not have to go get a permit or permission.
If you're a person without a badge and you're carrying a firearm, you're a bad guy. And so I think this addresses that.
Your responsibility also just increased. More people are going to be legally armed in more places. That raises the stakes for every gun owner to train properly, to understand use of force laws, and to carry with the discipline this right demands. Do not let anyone use this ruling as an excuse to be reckless. When you carry, you represent every person who exercises this right. Act like it.
State bans on assault weapons, and the Supreme Court is at this point staying out of the fight.
We believe the right to keep and bear arms shall not be infringed, period.
The Supreme Court said that the Second Amendment does provide an individual right to have a gun.
In 2024, a Cowlitz County judge overturned the law, but the Washington State Supreme Court upheld it.
And people are worried for their lives. They're going to stay back away from evil.
Here is your status check right now. The ruling is in effect. It has not been stayed or overturned as of today. Your existing permit is not worthless. Keep it, because it may still serve you in states outside this circuit's jurisdiction and during interactions with law enforcement still operating under the old framework.
Includes the sale, import, manufacturing, and distribution of these magazines that hold more than 10 rounds.
A major win for gun safety advocates. The Supreme Court will not hear a challenge to Maryland's assault weapons ban.
Large capacity magazines are not necessary for self-defense and are routinely used in mass shootings.
If you live in a state under this circuit, you're no longer legally required to obtain a permit to carry concealed, but you still must comply with all other applicable federal and state laws regarding where you carry and whether you're a prohibited person. Watch your state legislature closely over the next 30 to 60 days because emergency legislation is coming. I will be covering every single development as it happens. That is it for today, folks. See you in the next video.